What is harassment and bullying at work? What is harassment at work? The interchangeable use of the words harassment and bullying can lead to a misunderstanding of what each one relates to. They are legally distinct concepts, and so a behavior can be deemed either bullying or harassment, not both. This code refers to behaviors which come within the definition of workplace bullying only. The code does not extend to harassment under the Employment Equality Acts 1998 to 2015. Harassment or sexual harassment, for the purposes of the Employment Equality Acts, is any unwanted conduct related to any of the discriminatory grounds under the Employment Equality Acts. Sexual harassment is any form of unwanted, verbal, non-verbal, or physical conduct of a sexual nature. Discrimination on the basis of the 9 grounds specified in the Acts: gender, civil status, family status, sexual orientation, religion, age, disability, race, and membership of the traveler community, comes under the remit of the Employment Equality Acts, and promoting awareness of equality in the state is the responsibility of the Irish Human Rights and Equality Commission, IHREC. In this regard, IHREC has published a code of practice on sexual harassment and harassment at work, giving practical guidance on addressing issues around harassment at work. Statutory Instrument 208 of 2012 Employment Equality Act 1998 Code of Practice Harassment Orders 2012. While this code refers to workplace bullying only and doesn't include harassment cases, this does not prevent employers from having one policy document encompassing procedures for processing both bullying and harassment cases. It is, however, important to reiterate that where individuals reference a bullying and harassment case, the two are distinct concepts, and the agencies overseeing this code only have a remit for bullying. What is bullying at work? For the purposes of this code, bullying in the workplace is defined as follows. Workplace bullying is repeated, inappropriate behavior, direct or indirect, whether verbal, physical, or otherwise, conducted by one or more persons against another or others at the place of work and or in the course of employment, which could be reasonably regarded as undermining the individual's right to dignity at work. An isolated incident of the behavior described in this definition may be an affront to dignity at work, but as a once-off incident is not considered to be bullying. This code does not aim to address physical assault at work. The HSA advises that where it may be a risk or where it has occurred and is therefore established as a future risk, the employer has and uses a dedicated policy concerning violence and assault and retains and promotes a zero-tolerance approach to such behavior. From any quarter, violence is a criminal matter and should also be reported to Angada Siosana. How does bullying manifest itself within workplaces? In line with the above operational definition, workplace bullying should meet the criteria of an ongoing series of an accumulation of seriously negative targeted behaviors against a person or persons to undermine their esteem and standing in a harmful, sustained way. Bullying behavior is offensive, ongoing, targeted, and outside any reasonable norm. A pattern and trend must be involved so that a reasonable person would regard such behavior as clearly wrong, undermining, and humiliating. It involves repeated incidents or a pattern of behavior that is usually intended to intimidate, offend, degrade, or humiliate a particular person or group of people. Example, BDO Unibank Regis Center, year 2019. Subject of harassment, a bank teller in BDO Unibank Regis Center. She was bullied multiple times and in number of ways by multiple bank employees that year. She reported it, including their employee numbers. But the intention is not important on the identification process. Bullying activities involve actions and behavioral patterns, directly or indirectly spoken or written, and could include the use of cyber or digital means for the goal of bullying. Such bullying events delivered through cyber means may also be covered by the requirements of the 2005 Act. Behavior which makes for a bullying pattern will likely include not just one, but a range of the following behaviors. 1. Exclusion with negative consequences. 2. Verbal abuse or insults. 3. Being treated less favorably than colleagues in similar roles. 4. Belittling a person's opinion. 5. Disseminating malicious rumors, gossip, or innuendo. Socially excluding or isolating a person within the work sphere. Intrusion, pestering, spying, or stalking. Intimidation, aggressive interactions. Excessive monitoring of work. Withholding information necessary for proper performance of a person's job. Repeatedly manipulating a person's job content and targets. Blaming a person for things beyond their control. Use of aggressive and obscene language. Other menacing behavior. Who bullies at work? It is not possible or advisable to engage in guesswork or stereotyping in relation to those who bully. It may be that those who bully have general difficulty working with others, adapting to changing circumstances, or handling conflict. However, people with these characteristics may also not bully, so each case should be taken on its own merit, as generalizations are unhelpful in resolving bullying complaints. Good job design for all, adequate and effective training for all, and proper supervision can help ensure a workplace where any conflict or issues around the behaviors are dealt with fairly and effectively. Why deal with bullying at work? A feeling of being victimized or targeted negatively impacts performance and productivity at work as well as a person's mental well-being. And it is best to prevent situations arising where bullying is facilitated. Bullying can have serious effects for both the person being bullied, for an individual who wrongly feels bullied but who is engaged instead in a conflict situation. And for those who are accused of bullying, for an employer, bullying can result in dysfunctional work environment, low morale, lost time, and litigation issues. Before this bullying in this bank teller, this bank teller has not met any strangers in dating apps. But because of the developed result of the bullying, the dysfunctional work environments, the low morale and lost time, as well as other psychological effect, that prompts her to engage in immoral acts. Is that a good reason? What is not bullying at work? It is important to distinguish bullying from other inappropriate behaviors or indeed appropriate workplace engagement. As set out in the definition above, a once-off incident and bullying behavior may be an affront to dignity at work and may be unsettling, but does not of itself make for an adequate level of distress as to fall within the definition of bullying, and other remedies should be sought for these scenarios. As a once-off, such behaviors cannot be presumed to be done in targeted, purposeful, and unremitting way. Apart from once-off behaviors, other ongoing behaviors which may upset or unsettle a person may not come within the bullying definition either. Behavior considered bullying by one person may be considered routine interaction by another, so the reasonableness of behaviors over time must be considered. Disrespectful behavior, while not ideal, is not of itself bullying. Conflicts and disagreements do not of themselves make for a bullying pattern either. There are various workplace behavioral issues and relationship breakdowns which are troubling, upsetting, and unsettling, but are not of an adequate level of destructiveness to meet the criteria required for a bullying case. Objective criticism and corrections that are intended to provide constructive feedback to an employee are not usually considered bullying, but rather are intended to assist the employee with their work. Bullying does not include 1. Expressing differences of opinion strongly. 2. Offering constructive feedback, guidance, or advice about work-related behavior which is not of itself welcome. 3. Ordinary performance management. 4. Reasonably corrective action taken by an employer or supervisor relating to the management and direction of employees, for example, managing a worker's performance, taking reasonable disciplinary actions, or assigning work. Or workplace conflict, where people disagree with or disregard the other's point of view. This list is not exhaustive. Who is involved in bullying at work? Bullying at work can involve people in many different work situations and at all levels, including 1. Manager or supervisor to employee. 2. Employee to supervisor or manager. 3. One employee to another or group to group. 4. Customer, supervisor, manager to business contact. Or 5. Client or customer to employee. What is harassment and bullying at work? Factors which are known to be associated with a risk of bullying at work are high turnover of staff, high absenteeism, and or poor morale. Mismanagement or poor management of relations in the workplace. Bullying is more likely to be a factor in workplaces that do not have an effective management system based on respect and awareness or sensitivity to the impact of behaviors on others. Gender or age status imbalance. Other factors, composition of the workforce, interface with the public, history of tolerance of unacceptable behavior, lack of inadequate procedures or no adherence to procedures, and absence of clear reporting structures and clear job role descriptions. What are the effects of bullying at work? Workplace bullying and related complaints can have a range of effects on all concerned, the individual being bullied, of course, but also team members, colleagues, others in the organization, and the person being accused of bullying. For the employer, the effects can include reputational damage, absences of employees from the workplace, reduced productivity, increased cost, poor morale, and loss of respect for managers and supervisors. For the employee concerned, the target of bullying behavior, the effects can include stress, associated physical and or mental ill health, low morale, reduced performance, and lower productivity. Some people decide to leave their employment, exposing themselves to financial and other strains by so doing. For an innocent party who is the subject of a complaint or unaware of the effects of the behavior, the person accused of bullying, the consequences can likewise be significant in terms of anxiety, panic, distress, and potential social embarrassment, career damage. The effects of even one complaint or alleged bullying are pervasive across an organization. Both individuals involved will likely be negatively impacted, as may their respective teams, managers, and the broader groups and co-workers around them at the workplace. The spiraling negative consequence of bullying claims cannot be overstated, so it is in the best interest of all concerned to have robust preventive approaches and effective, clear, transparent procedures in place, which are used effectively. All involved, but especially managers and those in positions of authority, should be competent and capable of managing such matters efficiently and effectively. Roles and responsibilities in that regard should be made known at all. Management of bullying at work. Prevention. Every individual in the workplace has a role in promoting a positive workplace free from bullying behavior. Role of employers. Each employer should uphold the duty to manage and conduct work activities in such a way as to prevent any improper conduct or behavior likely to put at risk an employee's safety, health, or welfare at work. This duty on employers means that they must act reasonably to prevent workplace bullying patterns developing, and where there are complaints, the employer must react reasonably, assess a complaint, record actions, and put in place a suitable response based on each case arising. Prepare a safety statement under Section 20 of the 2005 Act based on the identification of the hazards to safety, health, and welfare at the place of work, an assessment of the risk involved, and setting down the preventive measures necessary to protect safety, health, and welfare. Risk is the likelihood of a hazard causing harm and the extent of that harm. Develop a proper workplace anti-bullying policy in consultation with employees to ensure a system is in place for dealing with complaints and that disciplinary action may follow where bullying is found to have occurred. See template in Appendix 1. Consultation with employees on health and safety matters is required under Section 26 of the 2005 Act, in addition to the requirements of Sections 8 and 9 of the Act. Management of bullying at work. Role of employees. Each employee should create a cooperative relational climate within the workplace by their own behavior. How they behave and how that behavior is responded to feeds into a broader sense of what is acceptable. Employees, both individually and within teams and groups, have a role in promoting positive behavior to others, relating in clear, civil, and respectful ways to everybody in the workplace. Employees have duties under the 2005 Act to conduct themselves properly in relation to others at work. Under Section 13, employees' duties include to comply with the relevant statutory provisions as appropriate and take reasonable care to protect his or her safety, health, and welfare, and the safety, health, and welfare of any other person who may be affected by the employee's acts or omissions at work. Cooperate with his or her employer or any other person so far as is necessary to enable his or her employer or the other person to comply with the relevant statutory provisions as appropriate and not engage in improper conduct or other behavior that is likely to endanger a person's own safety, health, and welfare at work or that of any other person at work or during the course of their employment. Organizational structure. The culture of an organization is an important factor in creating, establishing, and maintaining a positive workplace environment free from bullying, intimidation, or any ongoing negative behavior which might lay the foundation stone for a bullying culture. There are several elements important to a positive workplace, including good leadership, leading by example, a culture of involvement in the proper flow of communication, intolerance of inappropriate behavior, training of staff on acceptable behavior or conduct, an open and transparent pattern of relating based on mutual respect and dignity for all. A positive culture is one in which employees are comfortable raising issues of concern to them, especially of inappropriate behaviors, and where there are supportive, effective, and fair processes underpinning this in place. Preventive measures or actions. Promotion and reinforcement of a positive workplace culture. Effective anti-bullying policies developed, used, and promoted regarding improper and proper behaviors. Widespread policy awareness. Appropriate training as required for those managing complaints and for line management. Contact person, appropriate advisory, support services available where possible. Clear roles and goals for all. Go to how to prepare an anti-bullying policy in Appendix 1. Contact person role. There may be value in appointing a contact person who acts as the first step for anyone inquiring about a possible bullying case. Where the organization can support this, it often helps to resolve matters earlier and more effectively. The role of the contact person generally would be a supportive one, to listen and offer guidance on options in line with company policy and procedures, all on strictly confidential basis. This may not be practical for all organizations, however, where it is the chosen route, personnel for this role should be carefully selected and trained. The main purpose of the role is supportive listening and information provision. The contact person will have no role in the investigation of any complaints and should not be tasked with any further involvement in the details or right and wrongs of a complaint. Employers may also utilize previously chosen designated persons for roles within this arena, but as a contact person, they will thus have no role in investigations. Intervention in workplace bullying. Responding to a workplace bullying complaint at the workplace. Early intervention matters. Any complaint about or awareness of alleged bullying requires quick, calm, and consistent attention. As a general principle, it is worth emphasizing that early intervention offers the best possible potential for a good outcome, particularly regarding restoring workplace relationships. However, this does not equate with a rushed approach. Each case should be treated on its own merit. A matter that is protracted for whatever reason becomes more difficult to resolve in a positive way. Set out hereunder is both an informal and formal procedure for dealing with a workplace bullying complaint. The value of mediation. Mediation is an important consideration for resolving issues at an early stage. It is an informal, voluntary process where an impartial and competent third party enables individuals to work through conflict or disagreement. With a view to improving the relationship, it is a valuable tool at any stage in a procedure, but particularly beneficial at the earliest possible stage. It is established that the earlier a mediation process is used, the greater the potential for resolving the matters satisfactorily. It is important that suitably qualified mediators, whether internal or external, are used. Informal process. Initial informal process. A prompt and informal problem-solving approach offers the best potential for addressing allegations of bullying effectively. This collaborative and non-adversarial approach is particularly important in situations where people must continue to work together into the future. There are several elements to a good informal process. 1. People being confident that they will be listened to, will be taken seriously, and that their issues will be assessed fairly, quickly, and effectively. 2. Managers having the confidence and capacity to engage on such issues and to respond and consult appropriately. 3. Confidentiality to be respected by all. 4. A focus always on the future workplace relationship and the problem-solving orientation. Intervention in workplace bullying. An informal approach may effectively address the unwanted behavior without recourse to any other action. Sometimes the person who is alleged to be engaging on the behavior is genuinely unaware that the behavior being complained of is disrespectful or unwelcome or undermining and or causing distress. Recommended steps in an informal process are: 1. In the first instance, the unacceptable behavior acts should be raised by the target employee, the person who feels bullied, with the person involved, but only if they feel comfortable in doing so. This should be done quickly and calmly, focusing on the facts regarding acts done and their consequences. If it is more suitable, the individual who perceives that they are the recipient of an unacceptable behavior should put their concerns in writing, again focusing on the offending acts and their effects on them. Where an employee perceives that the concerns relate to an immediate manager, the employee may wish to discuss the matter informally with their manager or a person at the next level of management. The employee may wish to avail of the support of a contact person, where applicable, for guidance and get a copy of the anti-bullying policy document. The focus of the above is to seek to resolve the matter informally by agreement without recourse to any other step. An informal discussion is often sufficient to alert the person concerned to the effects of the behavior alleged and can lead to a greater understanding and an agreement that the behavior will stop. It can also lead to an explanation of the original intention of the behavior and or an agreement to modify the behavior. On the other hand, it may be that the behavior is valid and reasonable and the reaction of the offended party is at odds with a generally accepted understanding of the behavior. In the context of being aware of an allegation by an employee and whether the matter has been resolved, there may be value in the employer nominating a person to review good practice, generally in the workplace around dealing with such matters. For example, an awareness campaign highlighting examples of appropriate behavior as well as improper behavior and some explanation of effects to be brought to everyone's attention. A brief written record of the matter should be kept in line with relevant data, protection legislation, and agreed outcomes and dates noted by the relevant person responsible for managing the complaint. Intervention in workplace bullying. In smaller organizations, the employer or person heading that organization should not try to informally resolve a complaint personally, but should instead refer the matter for resolution management to a senior manager or such other persons as may be agreed. This is to prevent any duplication of roles of the employer. Should be the issue be later on referred to them for a judgment or appeal. In such organizations also where internal structures are limited, if the complaint made is against a senior person with the enterprise, it may be necessary to use the expertise of an independent professional body to access mediation or conciliation or some other form of resolution. Such bodies may include the mediation services of the WRC. Even in larger organizations, external assistance may be required in order to initiate an effective early solution. Secondary informal process. If the above is unsuccessful or if the complainant or the employer deem it inappropriate for the seriousness of the issues, this more protracted yet still informal system can be put in place. The employer may nominate a separate person who has had appropriate training and experience and who is familiar with the procedures involved to deal with a complaint on behalf of the organization. These persons should not be the contact person. They may be a supervisor or manager or someone in authority within the organization. For each complaint that arises, such a person should be assigned to deal with that particular case. This is a very important role and pivotal in altering bullying cultures and handling complaints effectively at the informal stage. Effective guidance and training should be in place for those who are engaged at this level with the process. The complaint may be verbal or written. If verbal, a written note of what is being complained about should be taken by the nominated person and a copy given to the complainant. This nominated person, who may be a manager managing the complaint, should then establish the facts, the context, and then the next course of action in dealing with the matter under the informal procedure. If the complaint concerns alleged bullying as defined and includes concrete examples of inappropriate behavior, the person complained against should be presented with a complaint and their response established. Thereafter, a method should be agreed to progress the issue, the resolution, so that both parties can return to a harmonious working environment without bullying being a factor. If the behavior complained about does not concern alleged bullying as defined, an alternative approach should be put in place and a rationale recorded. If there are no concrete examples given, it must be deemed that there is no complaint to be answered by the person complained about, as they have no recourse to repudiating an accusation that doesn't give any specifics. Line managers should be kept informed as appropriate about the process in train, steps to stop the bullying behavior where it has been partly or fully identified, and monitoring of the situation along special specified lines should be implemented with both parties. This may involve a direct or indirect approach and possible resolution through a program to change behavior. It may also involve mediation by an agreed mediator who is practiced in dealing with alleged bullying at work. Enough time needs to be allowed for the mediation or ongoing monitoring process to be successful and behavior change to be realistically achieved over the longer term. It may be necessary to consider if other working arrangements are required or feasible during this short-term phase. A proposal should be made, considered, and an action and timeframe established, signed, and dated, preferably by both parties. The nominated person who was responsible for managing the complaint should keep a nominal record of all stages: the complaint, the first meeting, action, agreed, and signed records of the final meeting. The purpose of the records, which do not include the detail of discussions, is to provide evidence of the complaint having been met with an organizational response and attempt at resolution. Records should be kept in accordance with relevant data protection legislation, Section 2(1) governing retention within an agreed human resources system, and be available only to that legislation. Information disclosed in the course of mediation must remain within the mediation process and must not be given by the mediator to anyone or to an investigator if there is a subsequent investigation at formal stage. Confidentiality is crucial for this stage to be effective, and breaches of confidentiality where exposed should be met with sanctions highlighted in advance. Intervention in workplace bullying, closure at informal stage. The following are some of the steps that should ideally be used to close off informal proceedings, ensuring that both parties have their rights met. 1. Obtain closure after a resolution is found through informal procedures. Both parties should be given support or periodical reviews insofar as is reasonable, which, if necessary, could include counseling or other appropriate interventions or support services. 2. Where a complaint has been assessed as vexatious, the matter should be progressed through other relevant procedure. 3. In many situations with the cooperation of all parties, the matter can rest here. Formal process. It is good practice that all informal resolution avenues as set out above should be contemplated and where appropriate exhausted before a formal process is invoked. Proceeding to a formal process should not be viewed as automatic, and it is important that it is recognized that it is the reasonable evidence-based decision of management. Escalating a complaint to a formal process should only be done following a review of all aspects and the circumstances surrounding matters complained about. Being able to evidence a reasonable decision-making process is important and may be required to defend the employer's duty at a later stage, so a record of that should be kept by the appropriate person acting for the employer. This process includes a formal complaint and a formal investigation. The purpose of an investigation is to set up a fact-finding approach and determine the facts and credibility or otherwise of a complaint of alleged bullying. It is a significant step, and all parties should be aware of possible consequences. In particular, an investigation will make it more difficult to restore normal workplace relations and may not have the desired outcome for the parties concerned. The outcome of an investigation may eventually separately lead to a disciplinary process being instigated in respect of the person complained about. But the investigation itself will be a fact-finding, one with a focus on what or did not occur. Where an investigation is to be carried out, the procedures outlined below should be followed. Formal complaint. The complainant should make a formal complaint in writing that should be signed and dated. Where there is not possible, a written record should be taken of the complaint by the assigned person and signed by the complainant and dated. The complaint should be confined to precise details of alleged incidents of bullying, including their dates and names of witnesses where possible. The complainant and the respondent should be advised of the aims and objectives of the formal process, the procedures and approximate ideal time frame involved, and the possible outcomes. Both parties should be assured of support as required throughout the process. An initial meeting should be organized by the employer at which each person is met with separately, starting with the person making the allegation. The other party, when met with, should be given a copy of the complaint in full, and both should be given any relevant documents, including the company's anti-bullying policy. Investigation. 4.2.2. The investigation should be governed by terms of reference which should include the following. 1. The investigation should be conducted in accordance with the employment's anti-bullying policy, which should reflect this code of practice. 2. An indicative timescale for its completion. This time frame should be proposed and its rationale explained. 3. The scope of the investigation sets out the procedure to be adopted for findings of fact related to the complaint and the statement that the investigator will consider, based on the facts before them, whether the behaviors complained about on the balance of probabilities have occurred. 4. The confidentiality of the process should be emphasized to all concerned. All parties to the process have a responsibility to participate without undue delay in any investigation initiated in response to an allegation of bullying. The scope of the investigation should indicate that the investigator will decide, based on the facts before them, whether the behavior complained about may, on the balance of probabilities, have occurred. The investigator should not uphold or dismiss the allegations and or suggest or impose sanctions. Statements from all parties, including witnesses, should be recorded in writing, as the use of written statements tends to make matters clearer from the outset and maintains clarity throughout the investigation. Copies of the record of their statements should be given to those who make statements to the investigator. Copies should also be provided to the complainant and the person complained about and should result in findings of fact only. If possible, all parties should continue to work normally during the investigation. The objective of an investigation is to ascertain whether, on the balance of probabilities, the behaviors complained about occurred, it having already been established that the behaviors come within the description of workplace bullying. Details of the complaint, responses of the person complained of, witness statements, and other relevant evidence are relied on for this purpose. The investigation should be conducted by either a designated member of management as outlined earlier in this code, or if necessary, for example, in the case of any possible conflict of interest, an independent third party. In either case, the person nominated should have appropriate training and experience and be familiar with the procedures involved. The investigation should be conducted thoroughly, objectively, with sensitivity, utmost confidentiality, and with due respect for the rights of both the complainant and the person complained of. The investigator should meet with the complainant, the person complained about, and any witnesses or relevant persons on an individual confidential basis with a view to establishing the facts. A work colleague or employee trade union representative, provided the person has representation in line with the principles of natural justice and fair procedure, may accompany the complainant and the person complained of, if so desired. The investigation will consider all material and evidence before it, and the decision will be made on balance of probability as to whether the complaint is valid. If the investigator concludes that the accused employee has a case to answer on the balance of probability, then the investigator may recommend whether or not the employer should invoke the disciplinary procedure. Appeals. Within the workplace formal system, an appeals process for both parties should be in place. The reason for the appeal should be outlined in writing to management if such an option is being taken. The time period for an appeal should be specified in the policy. The appeal should be heard by another party of at least the same level of seniority as, but preferably more senior than, the original investigator. These parties should have had no involvement in the investigation. The appeal should focus on the conduct of the investigation in terms of fair process and adherence to procedure. It should be noted that an appeal is not a rehearing of the original issues. The outcome of the appeal should be final insofar as the employer duties under health and safety legislation is required. Very small and micro organizations will need to consider at the outset of the formal process how they would manage a request for appeal and how this may require outside independent support. Management of malicious complaints. A malicious complaint can be described as an allegation being made without foundation and with malicious intent, where a person knowingly or without regard to whether it is true or not accuses another person of allegedly bullying them. This could also cause to where one person maliciously complains of someone allegedly bullying a third party without fully exploring the veracity of the claim. A malicious complaint has the power to disrupt another person's life to a significant extent, and the potential damage should not be underestimated. Being accused of bullying can have a serious impact on any person and reduce his or her reputation in the eyes of others, even if later shown to not have been proven. Those making complaints and those involved in early assessment of the circumstances of a complaint should always be mindful of the context and situational aspects of the event and accept the different perspectives and points of view different people bring to the same event. Making a malicious complaint, if proven, can have serious implications for the employment of the person making such a complaint, and this includes disciplinary action where established. It must be accepted that investigations can result in very divisive relationships for individuals, teams, and departments. Some type of reconciliation or rehabilitative meetings or team working session may be considered as appropriate to restore healthier working communication for the future. In many situations, with the cooperation of all parties, the matter can rest here. The employer should decide, in light of the investigator's report and the findings of fact therein, what action is to be taken arising from that report. The employer shall then in writing inform both the complainant and the person complained against of the next steps. At the end of the formal process, documentation should be kept by the employer in line with the relevant data protection legislation. If internal procedures do not resolve a bullying complaint, if full utilization of the range of available internal procedures has not resolved a bullying complaint, the matter may be referred to a WRC adjudicator under Section 13 of the Industrial Relations Act 1969, see Section 6.2. The adjudicator will not rehear the substance of the case. A number of outcomes are possible. The adjudicator may conclude, not include, that the investigation was conducted properly and fairly, and hence its conclusions should stand. The adjudicator may, on the other hand, conclude that the investigation process was flawed in some respect and could recommend, for example, that the investigation be reheard. Where a person makes a complaint to the HSA regarding a complaint made by them or a complaint made against them, the HSA will instigate its own procedures in line with its statutory remit as outlined in the next section of this code. Communications of outcomes. Effective communications of any outcome is critical. In this regard, employers should ensure that outcomes are communicated sensitively and fairly. All parties directly involved in the complaint, the complainants, and the respondent are entitled to know whether the complaint is upheld in whole or in part. If it is not upheld, and the reasons why, for the avoidance of doubt, specific details of disciplinary action to be taken against any party are confidential and other parties are not entitled as a matter of course to receive this information as part of the outcome. Health and safety duties on employers require that having identified a hazard, they must put control measures in place. These involve prevention actions, manage elimination of the behavior, protective measures, and remedial actions where appropriate. They should also keep records of all such actions taken. Role of the HSA. There are a range of state and non-state agencies which have a function in the area of workplace bullying. Different pieces of legislation also have a bearing in preventing and managing bullying cases. Some before the event, others in the management of cases as they arise, and others still after the fact. As this code has been developed by two state agencies, only the roles of these two agencies are outlined here. However, interested parties can also seek information on the varying roles and scope of other organizations elsewhere. The HSA operates under the statutory powers of the 2005 Act. Its purpose is to provide protection for employees in all places of work in the Republic of Ireland. The overarching tenet of the 2005 Act is to oversee the employer duty to ensure everyone at work is provided with a workplace and system of work which is, as far as is reasonably practicable, free from risk to health and to safety. There are within the 2005 Act specific duties on employers and others on employees to uphold and promote this standard as well as healthy and safe culture. There are provisions within the 2005 Act which are relevant to the issue of workplace bullying, both directly or indirectly. Section 8(2)(b) directly references improper conduct and the employer duty to ensure the workplace has an adequate system in place to prevent such conduct. Section 19, hazard identification and risk assessment, and Section 20, safety statement, reference the employer duty to have in place adequate systems of work and to record these actions in written form. Section 13, duties of employee, includes the employee duties to cooperate with such employer activities. system for processing bullying complaint or cases. As well as engaging in promotion and awareness-raising activities, the HSA provides a public-facing phone and email workplace contact unit, WCU, where employees who consider themselves to be bullied can report their issue. Employees can either report it as a complaint, or if they are seeking information about the topic and or are unsure as to whether or not their experience is in fact bullying, they can contact WCU to make an inquiry. This latter approach will be recorded as a request for information, RFI. The WCU responds to RFIs by providing either a verbal or written answer to the customer, or if they are not in a position to answer the query, they will forward the RFI to an appropriate person who will respond where a complaint is made concerning bullying. It can be classified in various ways depending on its content and the nature of the complaint. The first filter every complaint goes through is to assess whether or not noting the behaviors accompanied of the issue falls within the definition and scope of bullying complaints. See what is bullying at work. If the complaint concerns a person who feels they are being bullied and what they describe falls within the scope of workplace bullying, and they report that the employer is not taking any action, that matter will be recorded by WCU and the employer contacted to assess the response and follow up to the matter insofar as the employer's action is concerned. Where the complaint is that the employer did take action, but the employee is unhappy with the action or the outcome of that action, the role of the HSA is to assess whether or not, insofar as is reasonably practicable, the employer's actions were adequate. If the complaint is from a person accused of bullying, similarly, the HSA role is the same, to assess the employer's processing of the matter. In each of the above scenarios, the HSA is a neutral party whose remit is to ensure the safety and health of the employee through the reasonable and practical actions provided for by employers in their systems of work, generally, and the management of the issue specifically. The HSA has the statutory remit to ensure employer duties of care to all employees and management of improper conduct at work. Where the hazard of bullying exists, it is upheld. The HSA can, where an employer fails to act reasonably in an existing bullying matter, issue enforcement action in various forms, from verbal advice to written advice, an improvement direction, or an improvement notice. The HSA can also, after investigation, forward a file with recommendations to the Director of Public Prosecution, DPP, for their decision as to the prosecution of employers where there is evidence that the employers have failed in their duty to protect an employee or employees from the harmful fallout of bullying. The HSA has no role in the sanction or disciplinary actions taken in these matters and does not have a role in mediation, negotiation, or conflict resolution between parties to a bullying case. Role of the WRC. The WRC's objective at all times is to achieve harmonious working relations between employers and employees. The Commission would always encourage local discussion on and resolution of disputes and issues which arise in the workplace, including cases of alleged bullying. The Workplace Relations Commission delivers several services which may assist. 1. Individual and collective workplace mediation, focus on seeking to resolve the matter at an early stage locally before a formal process is initiated. This is dependent on the agreement of the parties concerned to participate and is provided by the WRC on an ad hoc basis. 2. Workplace mediation provides a confidential, professional, efficient, and effective process to assist all parties in reaching a mutually acceptable agreement or outcome to a dispute or claim. This approach often helps to avoid more formal processes. 3. It is particularly suited to disputes involving individuals or small groups of workers who find themselves dealing with situations which may involve the following: interpersonal differences, conflicts, difficulties in working together, breakdown in a working relationship, reviewing overall workplace relations generally in organizations, and assisting with the implementation of positive engagement measures. The provision of adjudication services under Section 13 of the Industrial Relations Act 1969 following the exhaustion of internal procedures note the grounds of a referral to an adjudication officer are around the conduct of an investigation in terms of fairness and adherence to fair process and procedure. Role of the HSA and the WRC in the prevention of workplace bullying. Health and Safety Authority, HSA bullying, see definition. Box 1. I feel I am being bullied at work and want information or help. Box 2. I am unhappy with the outcome of an internal or in-house bullying procedure. Box 3. For advice request for information RFI. Box 4. To pursue implementation of anti-bullying policy complaint. Either request for information RFI or complaint employer duty of care MEF. Resolved not resolved WRC. Column 2. Workplace Relations Commission WRC bullying. See definition. An allegation of bullying in the workplace has been made. If both complainant and the respondent are agreeable, the assistance of the WRC can be sought to try and resolve the matter before a formal bullying investigation is initiated locally. There are two options. One, matter is resolved to the satisfaction of both parties, or matter is not resolved, continue with local formal procedure. Or, I am unhappy how the investigation into my allegation of bullying in the workplace was conducted. Followed by, make a referral to the WRC under Section 13 of the Industrial Relations Act 1969. Two options. The adjudication officer concludes that the investigation was conducted properly and fairly and the outcome should stand. Or, the adjudication officer concludes that the investigation was not conducted properly and issues a recommendation. Note, it should be noted that the system of industrial relations in Ireland is voluntary in nature and participation in processes under industrial relations legislation is by agreement with both parties to a dispute. The outcome from a hearing by an adjudication officer is by way of a recommendation and as such can be accepted or rejected by either both parties. There is a case that a former employee of a bank already filed complaints and asked assistance from legal boards, from universities, and informal legal complaints or legal help desk or legal aids or legal clinic. But all of those bullying reports, they are overlooked. According here, another role of the HSA and the WRC in the prevention of workplace bullying, Irish Human Rights and Equality Commission, IHREC, harassment under 9 grounds. I am being targeted or treated differently, discriminated against at work due to membership of one of the following categories. Might as well say, let us correct that, not overlooked, but it has been disregarded. 1. Family status. 2. Gender. 3. Civil status. 4. Sexual orientation. 5. Religion. 6. Race. 7. Age. 8. Disability. 9. Member of traveler community. How to prepare an anti-bullying policy. Prevention is the best way to avoid the risk of bullying at work. An effective policy and a strong commitment to implementing it is required. The purpose of an effective policy is not simply to prevent improper conduct and behavior, but also to encourage best practice and a safe and harmonious workplace where such behavior is unlikely to occur. Employers should therefore adopt, implement, and monitor a comprehensive, effective, and accessible policy on bullying at work. Preparing the policy, strategies to create and maintain a working environment in which the dignity and respect of employees are appreciated and upheld are most likely to be effective when they are jointly agreed. In this way, employers and other parties to the employment relationship can create an anti-bullying culture and share a sense of responsibility for that culture. In very small businesses which may not have an employee representative structure, the policy and strategy should be advised to all employees. The policy and complaints procedure should be adopted where appropriate insofar as is practicable with clients, customers, and other business contacts after consultation of negotiation with trade union or employee representatives on its content and implementation. Simple, direct language should be used in the policy. Information given to employees should be in a form, manner, and as appropriate language that is reasonably likely to be understood by the employees concerned. The policy document should be written, dated, and signed by a responsible person at senior management level and updated when appropriate. For example, following a change that might impact the validity of the original risk assessment. As required under safety and health laws and in keeping with normal industrial relations practice, there should be prior consultation and participation where appropriate regarding the policy and its implementation with employees or their representatives, including the safety representative or the safety committee. The policy should set out a complaints procedure as recommended within this code. It is prudent to keep a record of consultation actions in case of future requirement. Anti-bullying policy. Core elements and implementation steps. Employer's declaration. The anti-bullying policy should declare: 1. The employer's commitment to ensuring that the place of work is free from bullying at work and that the work environment is aimed at providing a high-quality product of service in an atmosphere of respect, collaboration, openness, safety, and equality. 2. That all employees have the right to be treated with dignity and respect at work. 3. That the risk of bullying has been assessed and preventive measures included where necessary in the safety statement. That consultation with employees or their representatives, including the safety representative and the safety committee as appropriate, has taken place as regards the risk of bullying at work and preventive measures. That human resource management policies and practices will strive to prevent bullying at work, that the policy will be updated to reflect the company's experiences in implementing its relevant changes in the workplace and any external factors that are relevant, that employees also have responsibility in creating and contributing to the maintenance of a work environment free from bullying or from conduct like to contribute to bullying. That complaints by employees of bullying at work will be treated with fairness, sensitivity, respect, and confidentiality for all parties concerned. That a person or persons alleged to have bullied and will be afforded natural justice and treated with fairness, sensitivity, and respecting the need for confidentiality with all parties concerned. That bullying at work by the employer, by employees, and by non-employees such as clients, customers, subcontractors, and business contacts will not be tolerated, and the appropriate employing organization should deal with the complaint in line with these procedures, which could lead to disciplinary procedures being applied. That following the application of the disciplinary procedure, if a vexatious complaint of bullying is substantiated, it may result in disciplinary sanction. And note, should disciplinary procedures be initiated following on from a bullying investigation, those procedures would fall outside the scope of this code. The policy should: 1. Describe what is meant by bullying at work as set out above under what is bullying at work. 2. Include a non-exhaustive list of examples of bullying behavior relevant to the particular employment. 3. Give the name or job title of the person who may be approached by a person wishing to complain or bullying at work. 4. State that protection extends to bullying at work by management, fellow employees, subordinates, clients, customers, and other business contacts, and beyond the place of work to off-site and to work-related social events. State that all complaints of bullying will be taken seriously and will be followed through to resolution, and that employees who make up complaint will not be victimized. Allocation of responsibilities as regards prevention of bullying at work. The policy should state that management, others in positions of authority, and workplace representatives have a particular responsibility to ensure that bullying at work does not occur and that complaints are addressed promptly. The policy should state that in particular, management should provide good example by treating all in the place of work with courtesy and respect, promote awareness of the policy and complaints procedures, be vigilant for signs of bullying at work through observation and through seeking employee feedback, and take action before a problem escalates. Deal sensitively with employees involved in bullying complaint, whether as complainant or alleged bully. Explain the procedures to be followed if a complaint of bullying at work is made. Ensure that an employee make a complaint is not victimized for doing so, and monitor and follow up the situation after a complaint is made so that the bullying at work does not recur.